Let's start with a review of real property, estates, and ownership. What is the primary characteristic of a fee simple estate? Is it A, it is limited to the lifetime of the owner? B, it provides the owner with the most complete set of rights? C, it automatically reverts to the state upon the owner's death? Or D, it is subject to conditions set by the previous owner? The answer is B. It provides the owner with the most complete set of rights. A fee simple estate is the most complete form of ownership, with the owner having the right to use, sell, or bequeath the property indefinitely. Which type of tenancy allows a tenant to remain on the property after the lease has expired without the landlord's consent? Is it A, tenancy at will? B, periodic tenancy? C, tenancy at sufferance? Or D, joint tenancy? The answer is C, tenancy at sufferance. Why this question may seem a bit tricky. The term tenancy at sufferance is often confused with tenancy at will, but the former specifically refers to a tenant staying without consent. Sarah leases an apartment for 1 year, but after the lease expires, she continues to pay rent monthly, which the landlord accepts. What type of tenancy does this situation describe? Is it A, periodic tenancy? B, tenancy at sufferance? C, tenancy at will? Or D, estate for years? The answer is A, periodic tenancy. This situation describes a periodic tenancy as the lease continues on a month-to-month basis with the landlord's acceptance of rent. What is the key difference between a joint tenancy and a tenancy in common? Is it A, joint tenancy allows unequal shares? B, tenancy in common requires all owners to agree on property decisions? C, tenancy in common includes the right of survivorship? Or D, joint tenancy includes the right of survivorship? The answer is D. Joint tenancy includes the right of survivorship. The key difference is the right of survivorship in joint tenancy, meaning the surviving owners automatically inherit a deceased owner's share. Tom and Jerry own a property as joint tenants. If Tom sells his interest to Mary, what is the resulting ownership structure? Is it A, joint tenancy between Mary and Jerry? B, tenancy in common between Mary and Jerry? C, Mary becomes the sole owner? Or D, joint tenancy between Tom and Mary? The answer is B, tenancy in common between Mary and Jerry. When Tom sells his interest, the joint tenancy is severed and Mary and Jerry become tenants in common.
How'd you do on the first 5 questions? Go ahead and subscribe to Birdsy now and turn your progress into exam day confidence. Ready to jump back in? Let's go.
Legal descriptions and land use controls. What is the primary purpose of a legal description in real estate transactions? Is it A, to provide a visual map of the property? B, to uniquely identify and describe the property? C, to determine the property's market value? Or D, to list the property's improvements? The answer is B, to uniquely identify and describe the property. A legal description uniquely identifies a property, ensuring clarity and preventing disputes over property boundaries. Which of the following is not a recognized method of legally describing real property? Is it A, mets and bounds? B, lot and block? C, government survey system? Or D, street address? The answer is D, street address. Why this question may seem a bit tricky. All options sound plausible, but street address is not a legal description method. Don is selling his property, which is described using the meets and bounds method. What should he ensure is included in the legal description to avoid boundary disputes? Is it A, a clear point of beginning and precise measurements? B, the property's street address? C, a list of all structures on the property? Or D, the property's assessed value? The answer is A, a clear point of beginning and precise measurements. Meets and bounds descriptions must include clear starting points and precise measurements to define boundaries. What is a zoning ordinance? Is it A, a federal law governing land use, B, a guideline for property tax assessments, C, a local law regulating land use and development, or D, a state requirement for environmental protection? The answer is C, a local law regulating land use and development. Zoning ordinances are local laws regulating land use and development to ensure orderly growth. Emily wants to build a fence on her property, but her neighbor claims it violates a local setback requirement. What should Emily check to resolve this issue? Is it A, her property deed, B, local zoning ordinances, C, her homeowner's insurance policy, or D, the neighbor's property survey? The answer is B, local zoning ordinances. Checking local zoning ordinances will clarify setback requirements and help resolve the dispute.
Have you noticed the code in the bottom corner? The next time you're stumped, take that code to birdsy.ai. You'll get immediate help, complimentary study sessions, and access to hundreds of additional questions. It's the best tool to help you pass with confidence.
Encumbrances, easements, and restrictions. What is an easement in real estate? Is it A, a type of property ownership, B, a legal right to use another's land for a specific purpose, C, a restriction on property development, or D, a temporary lease agreement? The answer is B, a legal right to use another's land for a specific purpose. An easement is a legal right to use another's land for a specific limited purpose, such as access to a road or utility lines. Which of the following is not a type of easement? Is it A, easement appurtenant, B, easement in gross, C, prescriptive easement, or D, restrictive easement? The answer is D, restrictive easement. Why this question may seem a bit tricky. Easements can be appurtenant or in gross, but a restrictive easement is not a recognized type. John has been using a path across his neighbor's land to access the beach for over 20 years without permission. What type of easement might he claim? Is it A, easement by necessity, B, easement in gross, C, prescriptive easement, or D, easement appurtenant? The answer is C, prescriptive easement. John might claim a prescriptive easement, which arises from continuous, open, and notorious use over a statutory period. What is a lien in the context of real estate? Is it A, a legal claim on a property as security for a debt, B, the type of property ownership, C, a restriction on property use, or D, a temporary lease agreement? The answer is A, a legal claim on a property as security for a debt. A lien is a legal claim or hold on a property, typically used as security for a debt or obligation. Sarah wants to build a fence on her property, but her neighbor claims it violates a restrictive covenant. What should Sarah do first? Is it A, ignore the neighbor and build the fence, B, review the property's deed and covenants, C, consult with a real estate agent, or D, file a lawsuit against the neighbor? The answer is B, review the property's deed and covenants. Sarah should review the property's deed and any recorded covenants to understand the restrictions before proceeding. Florida-specific property rights and homestead protections. What is the primary purpose of Florida's homestead exemption? Is it A, to protect a primary residence from forced sale by creditors, B, To reduce property taxes on all types of real estate. C. To allow homeowners to sell their property without paying capital gains tax. Or D. To ensure that property is passed to heirs without probate. The answer is A. To protect a primary residence from forced sale by creditors. The primary purpose of Florida's homestead exemption is to protect a homeowner's primary residence from forced sale by creditors, providing financial security and stability. In Florida, which of the following is not a requirement for a property to qualify for homestead protection? Is it A. The property must be the owner's primary residence? B. The property must be free of any mortgage? C. The owner must have legal or equitable title to the property? Or D. The property must be located within the state of Florida? The answer is B. The property must be free of any mortgage. Why this question may seem a bit tricky, the requirement about the property being free of any mortgage is misleading. Homestead protection applies regardless of mortgage status. Maria owns a home in Florida and recently married John, who has a significant amount of debt. How does Florida's homestead protection affect their situation? Is it A. Maria's home can be sold to pay off John's debts? B. John's creditors can place a lien on Maria's home? C. Maria's home is protected from John's creditors? Or D. Maria must refinance the home to protect it from creditors? The answer is C. Maria's home is protected from John's creditors. Florida's homestead protection shields the primary residence from John's creditors, ensuring that Maria's home cannot be forced into sale to satisfy John's debts. Which of the following statements about Florida's homestead protection is true? Is it A. It protects against all types of creditor claims, including tax liens? B. It applies only if the homeowner has lived in the property for at least 2 years? C. It allows the homeowner to avoid paying property taxes? Or D. It protects the home from forced sale due to most debts? The answer is D. It protects the home from forced sale due to most debts. Why this question may seem a bit tricky. The statement about protection from forced sale due to most debts is true, while the others contain misleading or incorrect information. Florida License Law and Agency. What is the primary function of the Florida Real Estate Commission? Is it A. To provide real estate loans? B. To regulate real estate practices? C. To set property tax rates? Or D. To manage state-owned properties? The answer is B. To regulate real estate practices. The FREC's primary function is to regulate real estate practices in Florida to ensure compliance with state laws and protect the public interest. Which of the following actions can FREC take against a licensee who violates Florida real estate laws? Is it A. Imprison the licensee? B. Issue a warning letter? C. Revoke the license? Or D. Increase the licensee's commission? The answer is C. Revoke the license. Why this question may seem a bit tricky. The options include actions that sound similar but differ in severity and applicability. FREC can impose fines, suspend, or revoke licenses, but not imprison licensees. A real estate agent in Florida is found guilty of misrepresenting property details to a buyer. What disciplinary action can FREC take in this situation? Is it A. Suspend the agent's license? B. Require the agent to retake the licensing exam? C. Impose a community service requirement? Or D. Increase the agent's continuing education hours? The answer is A. Suspend the agent's license. FREC can suspend the agent's license as a disciplinary action for misrepresentation, which is a serious violation of real estate laws. What is required for an individual to obtain a real estate license in Florida? Is it A. Only pass the state exam? B. Have a college degree in real estate? C. Complete an internship with a licensed broker. Or D. Complete a pre-licensing course and pass the state exam. The answer is D. Complete a pre-licensing course and pass the state exam. To obtain a real estate license in Florida, an individual must complete a pre-licensing course, pass the state exam, and meet other eligibility requirements. John, a licensed real estate broker in Florida, fails to renew his license on time. What must he do to continue practicing legally? Is it A. Continue practicing without renewal? B. Complete renewal requirements and pay late fees? C. Apply for a new license? Or D. Request a waiver from FREC? The answer is B. Complete renewal requirements and pay late fees. John must complete the renewal requirements and pay any applicable late fees to reactivate his license and continue practicing legally.
If you want more than just rapid-fire questions, head over to Birdsy.ai. You can take unlimited practice exams and get instant help from your personal AI study partner. It's like having a tutor 24/7. Try it free. You'll find a link in the description.
Authorized brokerage relationships, single agent, transaction broker, no brokerage. What is the primary duty of a single agent in Florida real estate transactions? Is it A. Fiduciary duty to the client? B. Limited representation to both parties? C. No representation to any party? Or D. Equal representation to all parties? The answer is A. Fiduciary duty to the client. A single agent owes a fiduciary duty to their client, which includes loyalty, confidentiality, and full disclosure. In Florida, which brokerage relationship allows a broker to represent both the buyer and the seller in the same transaction? Is it A. Single agent? B. No brokerage relationship? C. Transaction broker? Or D. Dual agent? The answer is C. Transaction broker. Why this question may seem a bit tricky. The term represent can be misleading, as transaction brokers provide limited representation without fiduciary duties. A seller hires a broker as a single agent to sell their home. The broker learns confidential information about the seller's financial situation. What is the broker's obligation regarding this information? Is it A. Share the information with potential buyers? B. Keep the information confidential? C. Disclose the information if it benefits the sale? Or D. Discuss the information with other agents? The answer is B. Keep the information confidential. The broker must maintain confidentiality as part of their fiduciary duty, even after the transaction ends. Which brokerage relationship in Florida does not require a written disclosure? Is it A. Single agent? B. No brokerage relationship? C. Dual agent? Or D. Transaction broker? The answer is D. Transaction broker. A transaction broker relationship does not require a written disclosure, unlike single agent and no brokerage relationships. A buyer approaches a broker to assist in purchasing a home, but does not want any representation. What type of brokerage relationship should the broker establish? Is it A. Single agent? B. Transaction broker? C. No brokerage relationship? Or D. Dual agent? The answer is C. No brokerage relationship. In a no brokerage relationship, the broker provides services without representing the buyer. Duties, disclosure rules, and relationship transition requirements. What is the primary duty of a transaction broker under Florida law? Is it A. To act as a fiduciary for both parties? B. To represent the buyer exclusively? C. To provide limited representation to both parties? Or D. To disclose confidential information to both parties. The answer is C. To provide limited representation to both parties. A transaction broker in Florida is required to provide limited representation to both parties in a transaction, ensuring fairness and honesty without full fiduciary duties. Under Florida law, when must a real estate licensee provide a single agent notice to a prospective buyer? Is it A, after showing the property, B, before showing the property, C, at the time of closing, or D, after the buyer makes an offer? The answer is B, before showing the property. Why this question may seem a bit tricky, the timing of disclosures can be confusing. The single agent notice must be provided before or at the time of entering into a listing agreement or before showing a property. A seller's agent in Florida is transitioning to a transaction broker role. What must the agent do to comply with legal requirements? Is it A, provide a transition disclosure and obtain written consent? B, notify the seller verbally and proceed with the transaction? C, continue as a seller's agent without any changes? Or D, provide a transition disclosure without needing consent? The answer is A, provide a transition disclosure and obtain written consent. The agent must provide the seller with a transition disclosure and obtain their written consent to comply with Florida law. What is required for a real estate licensee to transition from a single agent to a transaction broker in Florida? Is it A, no action is required? B, only verbal consent from the client? C, a new listing agreement? Or D, a transition disclosure and written consent? The answer is D, a transition disclosure and written consent. To transition from a single agent to a transaction broker, the licensee must provide a transition disclosure and obtain written consent from the client. During a property showing, a buyer asks the transaction broker if the seller is willing to accept a lower price. What is the broker's legal obligation? Is it A, disclose the seller's lowest acceptable price? B, encourage the buyer to make an offer? C, maintain confidentiality and not disclose the seller's position? Or D, ask the seller for permission to disclose? The answer is C, maintain confidentiality and not disclose the seller's position. The broker must maintain confidentiality and cannot disclose the seller's willingness to accept a lower price without the seller's consent. Broker supervision, office requirements, and record keeping. What is the minimum number of years a Florida broker must retain real estate transaction records? Is it A, 3 years, B, 5 years, C, 7 years, or D, 10 years? The answer is B, 5 years. Florida law requires brokers to retain real estate transaction records for at least 5 years, even if the transaction fails to close. Under Florida law, who is responsible for ensuring that all advertising by a real estate brokerage is compliant? Is it A, the individual sales associate, B, the office manager, C, the broker, or D, the marketing department? The answer is C, the broker. Why this question may seem a bit tricky. It might seem like the responsibility lies with individual agents, but the broker is ultimately responsible for all brokerage advertising compliance. A broker in Florida has multiple branch offices. One of the branch managers fails to maintain proper transaction records. Who is ultimately responsible for this oversight? Is it A, the broker, B, the branch manager, C, the sales associate, or D, the office administrator? The answer is A, the broker. The broker is ultimately responsible for ensuring compliance with record-keeping requirements across all branch offices. What is required for a broker to open a branch office in Florida? Is it A, a separate business license, B, a new broker license, C, approval from the local real estate board, or D, registration with FREC and a fee? The answer is D, registration with FREC and a fee. A broker must register each branch office with the Florida Real Estate Commission and pay the appropriate fee. A Florida broker decides to move their main office to a new location. What must they do to comply with state regulations? Is it A, notify clients within 10 days, B, notify FREC within 10 days, C, obtain a new business license, or D, submit a new office floor plan to FREC? The answer is B, notify FREC within 10 days. The broker must notify the Florida Real Estate Commission of the change of address within 10 days to remain compliant. Contracts. Which element is essential for a contract to be considered legally binding? Is it A, a written document, B, consideration, C, a witness, or D, a notary public? The answer is B, consideration. A legally binding contract requires mutual consent, consideration, capacity, and legality. Consideration refers to the exchange of value between parties. In a contract, what does the term capacity refer to? Is it A, the ability to perform the contract, B, the physical space needed for contract execution, C, the legal ability to enter into a contract, or D, the financial resources to fulfill a contract? The answer is C, the legal ability to enter into a contract. Why this question may seem a bit tricky, capacity refers to the legal ability of parties to enter into a contract, which is often confused with the ability to perform the contract. If a minor signs a contract, what is the status of that contract? Is it A, voidable, B, void, C, valid, or D, enforceable? The answer is A, voidable. Why this question may seem a bit tricky. A contract signed by a minor is typically voidable at the minor's discretion, which can be confused with being void or valid. John agrees to sell his car to Mary for $5,000, but later decides to sell it to someone else for a higher price. What is Mary's best course of action? Is it A, do nothing and look for another car, B, demand a refund of any deposit, C, negotiate a higher price with John, or D, sue for breach of contract? The answer is D, sue for breach of contract. Mary can sue for breach of contract since John agreed to sell the car to her and she has a valid contract. Sarah enters into a contract with a company to provide consulting services. The contract states that either party can terminate the agreement with a 30-day notice. What type of contract is this? Is it A, unilateral contract, B, bilateral contract, C, void contract, or D, executed contract? The answer is B, bilateral contract. This is an example of a bilateral contract where both parties have mutual obligations and can terminate with notice. Listing agreements and buyer brokerage agreements. What is the primary purpose of a listing agreement in real estate transactions? Is it A, to determine the property's market value, B, to authorize a broker to market the property and find a buyer, C, to transfer ownership of the property, or D, to set the closing date for the property sale? The answer is B, to authorize a broker to market the property and find a buyer. A listing agreement primarily authorizes a broker to act as the seller's agent in marketing the property and finding a buyer. In a buyer brokerage agreement, Who is responsible for paying the broker's commission? Is it A, always the buyer? B, always the seller? C, it depends on the terms of the agreement? Or D, the broker themselves? The answer is C, it depends on the terms of the agreement. Why this question may seem a bit tricky. The responsibility for commission payment can vary and is often misunderstood. Typically, the seller pays the commission, but the buyer may agree to pay if the seller does not. Sarah signs an exclusive right to sell listing agreement with a broker. If Sarah finds a buyer herself, what is the broker entitled to? Is it A, the broker is entitled to the full commission? B, the broker is entitled to half the commission? C, the broker is not entitled to any commission? Or D, the broker is entitled to a marketing fee only? The answer is A, the broker is entitled to the full commission. In an exclusive right to sell agreement, the broker is entitled to a commission regardless of who finds the buyer. What is a key characteristic of an open listing agreement? Is it A, it guarantees a commission to the listing broker? B, it restricts the property to one broker? C, it allows multiple brokers to market the property? Or D, it requires the seller to pay multiple commissions? The answer is C, it allows multiple brokers to market the property. An open listing allows multiple brokers to market the property, with only the broker who brings the buyer earning a commission. Tom enters into an exclusive agency listing with a broker. If Tom sells his house without the broker's help, what is the broker entitled to? Is it A, the broker is entitled to the full commission? B, the broker is entitled to half the commission? C, the broker is not entitled to any commission? Or D, the broker is entitled to a marketing fee only? The answer is C, the broker is not entitled to any commission. In an exclusive agency listing, the broker earns a commission only if they or another broker find the buyer, not if the seller does.
Did you get a different answer? Or maybe you have a question about the exam in general? Drop it in the comments below. We read and answer them personally.
Florida residential contracts, clauses, and addenda. What is the primary purpose of the as-is residential contract for sale and purchase in Florida? Is it A, to ensure the seller makes all necessary repairs before closing, or B, to allow the buyer to accept the property in its current condition? C, to guarantee the property is free of liens? Or D, to provide a warranty on the property's condition? The answer is B, to allow the buyer to accept the property in its current condition. The as-is contract is designed to allow the buyer to accept the property in its current condition without requiring the seller to make repairs. In a Florida residential contract, what is the effect of the time is of the essence clause? Is it A, it allows either party to extend deadlines at their discretion? B, it voids the contract if any deadline is missed? C, it emphasizes that deadlines are critical and must be adhered to? Or D, it requires the seller to complete repairs by a specific date? The answer is C. It emphasizes that deadlines are critical and must be adhered to. Why this question may seem a bit tricky. The clause emphasizes the importance of meeting deadlines, but it does not automatically void the contract if a deadline is missed. John is purchasing a home in Florida and discovers a lien on the property after signing the contract. What should he do according to the standard residential contract? Is it A, request the seller to clear the lien before closing? B, proceed with the purchase and assume the lien? C, cancel the contract immediately? Or D, negotiate a price reduction to cover the lien? The answer is A, request the seller to clear the lien before closing. The standard contract allows the buyer to request the seller to clear any liens before closing. What is the role of the financing contingency in a Florida residential contract? Is it A, to ensure the seller receives payment in full at closing? B, to obligate the buyer to pay cash if financing fails? C, to allow the seller to cancel the contract if financing is delayed? Or D, to allow the buyer to cancel the contract if financing cannot be secured? The answer is D, to allow the buyer to cancel the contract if financing cannot be secured. The financing contingency allows the buyer to cancel the contract if they are unable to secure financing within a specified period. Sarah is selling her Florida home and receives a request for repairs from the buyer after the inspection. What is her obligation under the as-is contract? Is it A, she must complete all requested repairs before closing? B, she is not obligated to make any repairs? C, she must negotiate which repairs to complete? Or D, she must lower the sale price to compensate for repairs? The answer is B, she is not obligated to make any repairs. Under the as-is contract, the seller is not obligated to make repairs, but the buyer can cancel the contract if unsatisfied. Contract performance, breach, and remedies. What is the primary remedy for a breach of contract in real estate transactions? Is it A, specific performance? B, monetary damages? C, rescission? Or D, injunction? The answer is B, monetary damages. The primary remedy for a breach of contract in real estate is typically monetary damages, which compensate the non-breaching party for losses incurred. In a contract breach, when might specific performance be ordered by a court? Is it A, when the breach involves a minor detail? B, when the contract involves a service? C, when the subject matter is unique? Or D, when the breaching party agrees? The answer is C, when the subject matter is unique. Why this question may seem a bit tricky. Specific performance is often misunderstood as a common remedy. It's actually ordered when monetary damages are inadequate, typically in unique property transactions. John sold his house to Mary, but before closing, he decided to sell it to someone else for a higher price. What remedy is Mary most likely to pursue? Is it A, specific performance? B, monetary damages? C, rescission? Or D, injunction? The answer is A, specific performance. Mary would likely pursue specific performance because real estate is considered unique and monetary damages may not suffice. Lisa entered a contract to buy a condo, but the seller failed to disclose a major defect. What remedy might Lisa seek if she wants to cancel the contract? Is it A, specific performance? B, monetary damages? C, rescission? Or D, injunction? The answer is C, rescission. Lisa might seek rescission to cancel the contract due to the seller's failure to disclose a material defect. Financing. What is the primary purpose of a conventional loan in real estate financing? Is it A, to provide government-backed financing for home buyers? B, to finance real estate purchases without government insurance? C, to offer low-income buyers subsidized interest rates? Or D, to refinance existing government-backed loans? The answer is B, to finance real estate purchases without government insurance? Conventional loans are primarily used for purchasing real estate without government backing, relying on the borrower's creditworthiness. Which type of loan typically requires private mortgage insurance when the down payment is less than 20%? Is it A, conventional loans? B, FHA loans? C. VA loans. Or D. USDA loans? The answer is A. Conventional loans. Why this question may seem a bit tricky, PMI is often associated with conventional loans, but the requirement can be confused with other loan types that have different insurance requirements. John is buying a home and is considering a loan that adjusts its interest rate annually after an initial fixed period. What type of loan is John likely considering? Is it A. Fixed-rate mortgage, B. Interest-only loan, C. Adjustable-rate mortgage, or D. Balloon mortgage? The answer is C. Adjustable-rate mortgage. John is likely considering an adjustable-rate mortgage, which has an initial fixed-rate period, followed by periodic rate adjustments. What is a key characteristic of a jumbo loan? Is it A. They are insured by the FHA, B. They offer lower interest rates than conforming loans, C. They are available only for first-time homebuyers, or D. They exceed conforming loan limits set by Fannie Mae and Freddie Mac? The answer is D. They exceed conforming loan limits set by Fannie Mae and Freddie Mac. Jumbo loans exceed conforming loan limits set by Fannie Mae and Freddie Mac, requiring higher credit scores and down payments. Lisa is evaluating a loan option that requires her to pay a funding fee but offers no down payment requirement. Which loan type is she likely considering? Is it A. FHA loan, B. VA loan, C. Conventional loan, or D. USDA loan? The answer is B. VA loan. Lisa is likely considering a VA loan, which requires a funding fee but typically has no down payment requirement for eligible veterans. Federal Mortgage Regulations, RESPA, TILA, ECOA, CFPB. What is the primary purpose of the Real Estate Settlement Procedures Act? Is it A. To regulate interest rates on mortgages, B. To ensure consumers receive disclosures about settlement costs, C. To set limits on mortgage loan amounts, or D. To provide tax benefits for homebuyers? The answer is B. To ensure consumers receive disclosures about settlement costs. RESPA aims to protect consumers by ensuring they receive disclosures about the costs of their real estate transactions and prohibiting certain practices like kickbacks. Under the Truth in Lending Act, which of the following is not required to be disclosed to the borrower? Is it A. Annual percentage rate, B. Total finance charge, C. Payment schedule, or D. Borrower's credit score? The answer is D. Borrower's credit score. Why this question may seem a bit tricky. TILA requires disclosure of terms like APR and finance charges, but not the borrower's credit score, which is often confused with loan terms. Sarah is applying for a mortgage and is concerned about discrimination. Which regulation ensures she is treated fairly, regardless of her race, color, religion, national origin, sex, marital status, or age? Is it A. Equal Credit Opportunity Act, B. Real Estate Settlement Procedures Act, C. Truth in Lending Act, or D. Consumer Financial Protection Bureau? The answer is A. Equal Credit Opportunity Act. The Equal Credit Opportunity Act ensures that all consumers are given an equal chance to obtain credit and prohibits discrimination. Which federal agency is responsible for enforcing the Truth in Lending Act? Is it A. Federal Reserve, B. Federal Trade Commission, C. Consumer Financial Protection Bureau, or D. Department of Housing and Urban Development? The answer is C. Consumer Financial Protection Bureau. The Consumer Financial Protection Bureau is the primary agency responsible for enforcing TILA, ensuring compliance with its provisions. John received a loan estimate form 3 days after applying for a mortgage. Which regulation mandates this disclosure timeframe? Is it A, Equal Credit Opportunity Act, B, TILA RESPA, Integrated Disclosure Rule, C, Real Estate Settlement Procedures Act, or D, Consumer Financial Protection Bureau? The answer is B, TILA RESPA Integrated Disclosure Rule. The TILA RESPA Integrated Disclosure Rule requires lenders to provide a loan estimate within 3 business days of receiving a mortgage application. Florida mortgage law and foreclosure procedures. What is the statutory redemption period in Florida after a foreclosure sale? Is it A, 30 days, B, none, C, 6 months, or D, 1 year? The answer is B, none. In Florida, there is no statutory redemption period after a foreclosure sale. Once the sale is confirmed, the right to redeem is lost. In Florida, which document primarily initiates the foreclosure process? Is it A, lis pendens, B, notice of default, C, notice of sale, or D, writ of possession? The answer is A, lis pendens. Why this question may seem a bit tricky. The term notice of default is often confused with the lis pendens, but the latter is the legal document that officially starts the foreclosure process in Florida. John is facing foreclosure on his Florida home and wants to understand his options. What is the most immediate action he can take to potentially stop the foreclosure process? Is it A, negotiate a short sale, B, apply for a loan modification, C, file for bankruptcy, or D, sell the property? The answer is C, file for bankruptcy. Filing for bankruptcy can immediately halt foreclosure proceedings due to the automatic stay provision, giving John time to reorganize his finances. What is the primary purpose of a deficiency judgment in Florida foreclosure law? Is it A, to evict the homeowner, B, to transfer property title, C, to prevent foreclosure, or D, to recover the remaining debt? The answer is D, to recover the remaining debt. A deficiency judgment allows the lender to recover the difference between the foreclosure sale price and the outstanding mortgage balance. Which of the following is not a requirement for a valid foreclosure sale in Florida? Is it A, proper notice of sale, B, public auction, C, minimum bid requirement, or D, court confirmation? The answer is C, minimum bid requirement. Why this question may seem a bit tricky. The requirement for a minimum bid is often assumed, but Florida law does not mandate a minimum bid for foreclosure sales. Finance calculations and borrower qualification. What is the primary purpose of calculating a borrower's debt-to-income ratio? Is it A, to determine the borrower's credit score, B, to assess the borrower's ability to manage monthly payments, C, to calculate the interest rate for the loan, or D, to establish the loan term length? The answer is B, to assess the borrower's ability to manage monthly payments. The DTI ratio helps lenders assess a borrower's ability to manage monthly payments and repay debts. It is a key factor in determining loan eligibility. A borrower has a stable job and a good credit score, but a high debt-to-income ratio. What might a lender be most concerned about? Is it A, the borrower's ability to manage additional debt, B, the borrower's employment stability, C, the borrower's creditworthiness, or D, the borrower's down payment amount, ... The answer is A, the borrower's ability to manage additional debt. Why this question may seem a bit tricky. A good credit score and stable job are positive, but a high DTI suggests potential difficulty in managing additional debt. John is applying for a mortgage and his lender requires a maximum debt-to-income ratio of 36%. If John's monthly income is $5,000, what is the maximum amount he can spend on debt payments each month? Is it A, $1,500, B, $1,600, C, $1,800, or D, $2,000? The answer is C, $1,800. John can spend up to 36% of his monthly income on debt payments, which is $1,800. Emily is considering a loan with a 5% interest rate. If the interest rate increases to 6%, how will this affect her monthly payments? Is it A, her monthly payments will decrease, B, her monthly payments will remain the same, C, her monthly payments will decrease slightly, or D, her monthly payments will increase? The answer is D, her monthly payments will increase. Why this question may seem a bit tricky. An increase in interest rate will increase monthly payments, but the exact impact depends on the loan amount and term. Transfer of title. What is the primary purpose of recording a deed in public records? Is it A, to provide public notice of ownership, B, to determine property taxes, C, to establish the property's market value, or D, to confirm the property's zoning classification? The answer is A, to provide public notice of ownership. Recording a deed provides public notice of ownership, protecting the owner's rights against future claims. Which of the following is not required for a deed to be valid? Is it A, grantor's signature, B, legal description of the property, C, delivery and acceptance, or D, recording in public records? The answer is D, recording in public records. Why this question may seem a bit tricky. All options seem necessary, but only delivery and acceptance are essential for validity, not recording. John sells his house to Mary, but the deed is not recorded. Later, John sells the same house to Tom, who records the deed. Who has the legal title to the property? Is it A, John because he was the original owner, B, Mary because she was the first buyer, C, Tom because he recorded the deed, or D, neither because the situation is unresolved? The answer is C, Tom because he recorded the deed. Tom has the legal title because he recorded the deed, providing public notice of his ownership. What is a quitclaim deed primarily used for? Is it A, to guarantee a clear title, B, to transfer any interest the grantor may have, C, to ensure the property is free of liens, or D, to provide a warranty of title? The answer is B, to transfer any interest the grantor may have. A quitclaim deed is used to transfer any interest the grantor may have without warranties. Samantha inherits a property from her uncle, but the title is still in his name. What must she do to legally transfer the title to her name? Is it A, file a deed of conveyance, B, pay property taxes, C, obtain a property appraisal, or D, apply for a zoning change? The answer is A, file a deed of conveyance. Samantha must file a deed of conveyance to legally transfer the title to her name. Closing procedures, escrow and settlement statements. What is the primary purpose of an escrow account in a real estate transaction? Is it A, to provide a loan to the buyer, B, to hold funds or documents until conditions are met, C, to determine the property's market value, or D, to record the deed with the county? The answer is B, to hold funds or documents until conditions are met. An escrow account holds funds or documents until the terms of the real estate transaction are met, ensuring both parties fulfill their obligations. In a closing statement, which party is typically responsible for paying the transfer tax? Is it A, the seller, B, the buyer, C, the lender, or D, the real estate agent? The answer is A, the seller. Why this question may seem a bit tricky, the responsibility for transfer taxes can vary by location, but typically, the seller pays this tax as part of the closing costs. During a closing, John discovers a lien on the property he is buying. What should be done to ensure a clear title? Is it A, proceed with closing and address the lien later? B, ignore the lien as it will not affect ownership? C, resolve the lien before closing? Or D, ask the seller to reduce the sale price? The answer is C, resolve the lien before closing. The lien must be resolved before closing to ensure John receives a clear title, typically by paying off the lien or negotiating its removal. What document is typically used to transfer ownership of real estate from one party to another? Is it A, a lease, B, a mortgage, C, a title insurance policy, or D, a deed? The answer is D, a deed. A deed is the legal document that transfers ownership of real estate from one party to another. Emily is closing on her first home and notices a discrepancy in the settlement statement. What should she do? Is it A, ignore it as it will be adjusted later? B, notify the closing agent immediately? C, ask her real estate agent to handle it after closing? Or D, proceed with closing and review it later? The answer is B, notify the closing agent immediately. Emily should immediately bring the discrepancy to the attention of her closing agent to ensure it is corrected before finalizing the transaction. Title insurance, abstracts, and chain of title. What is the primary purpose of title insurance in real estate transactions? Is it A, to guarantee the property's value? B, to protect against title defects? C, to ensure the property is free of liens? Or D, to provide legal advice on property disputes? The answer is B, to protect against title defects. Title insurance protects the buyer and lender from potential losses due to defects in the title that were not discovered during the title search. Which document is primarily used to trace the history of ownership of a property? Is it A, title insurance policy, B, deed, C, abstract of title, or D, chain of title? The answer is C, abstract of title. Why this question may seem a bit tricky, the terms title insurance, deed, and abstract of title are often confused. The abstract of title is specifically used to trace ownership history. Jessica is buying a home and discovers a lien on the property after closing. What role does her title insurance play in this situation? Is it A, it covers financial losses from undiscovered liens? B, it guarantees the removal of the lien? C, it provides legal representation to dispute the lien? Or D, it has no role since the lien was discovered post-closing? The answer is A, it covers financial losses from undiscovered liens. Title insurance protects Jessica from financial loss due to undiscovered liens or defects in the title that existed before her purchase. During a property sale, the seller provides an abstract of title. What should the buyer do next to ensure a clear title? Is it A, accept the abstract as proof of clear title? B, request a new deed from the seller? C, conduct a personal title search? Or D, obtain title insurance? The answer is D, obtain title insurance. The buyer should obtain title insurance to protect against any undiscovered defects in the title, even after reviewing the abstract.
If you want more than just rapid-fire questions, head over to Birdsy.ai. You can take unlimited practice exams and get instant help from your personal AI study partner. It's like having a tutor 24/7. Try it free. You'll find a link in the description.
Florida property taxes and transfer taxes. What is the primary purpose of a quitclaim deed in Florida real estate transactions? Is it A, to guarantee a clear title to the buyer? B, to transfer any interest the grantor may have without warranties? C, to ensure the property is free of liens? Or D, to provide a warranty of title to the buyer? The answer is B, to transfer any interest the grantor may have without warranties. A quitclaim deed is primarily used to transfer any interest the grantor may have in a property without guaranteeing the title's validity. In Florida, who is typically responsible for paying the documentary stamp tax on the deed during a property transfer? Is it A, the buyer, B, the lender, C, the seller, or D, the real estate agent? The answer is C, the seller. Why this question may seem a bit tricky, the responsibility can vary by local custom, but typically, the seller pays the documentary stamp tax on the deed in Florida. John is selling his property in Florida and has agreed to pay the documentary stamp tax on the deed. What is the tax rate he should expect to pay? Is it A, 0.70 per 100 of the sale price, B, 35 cents per $100 of the sale price, C, $1 per $100 of the sale price, or D, 50 cents per $100 of the sale price? The answer is A, $1.70 per $100 of the sale price. In Florida, the documentary stamp tax on the deed is typically calculated at a rate of 70 cents per $100 of the sale price. Mary is purchasing a home in Florida and wants to ensure she receives a clear title. Which type of deed should she request from the seller? Is it A, quitclaim deed, B, warranty deed, C, bargain and sale deed, or D, special warranty deed? The answer is B, warranty deed. A warranty deed provides the buyer with assurances that the title is clear and free of encumbrances, offering the most protection. Valuation and appraisal. What is the primary purpose of an appraisal in real estate? Is it A, to determine the highest possible selling price, B, to estimate the market value of a property, C, to calculate the property's tax liability, or D, to assess the property's condition? The answer is B, to estimate the market value of a property. An appraisal's primary purpose is to estimate the market value of a property, which is crucial for transactions, financing, and taxation. Which principle of value suggests that the value of a property is influenced by the cost of acquiring an equally desirable substitute? Is it A, principle of contribution, B, principle of conformity, C, principle of substitution, or D, principle of anticipation? The answer is C, principle of substitution. Why this question may seem a bit tricky. The principle of substitution is often confused with other principles like contribution or conformity, but it specifically deals with replacement costs. A homeowner is considering selling their property and hires an appraiser to determine its market value. The appraiser notes that similar homes in the area have recently sold for $300,000. What principle is the appraiser primarily using? Is it A, principle of substitution, B, principle of progression, C, principle of regression, or D, principle of change? The answer is A, principle of substitution. The appraiser is using the principle of substitution, which suggests the value is influenced by the cost of acquiring a similar property. Which of the following is not a recognized method of property valuation? Is it A, cost approach, B, sales comparison approach, C, income approach, or D, market trend approach? The answer is D, market trend approach. The cost approach, sales comparison approach, and income approach are standard valuation methods, while the market trend approach is not recognized. During an appraisal, the appraiser finds that the subject property is in a neighborhood where property values are increasing due to new developments. Which principle of value is most applicable in this situation? Is it A, principle of substitution, B, principle of contribution, C, principle of balance, or D, principle of anticipation? The answer is D, principle of anticipation. The principle of anticipation applies here, as future benefits from new developments are influencing current property values. Approaches to value: market, cost, and income. What is the primary basis for the market approach to property valuation? Is it A, comparable sales, B, replacement cost, C, income potential, or D, depreciation analysis? The answer is A. The market approach relies on comparing the subject property to similar properties that have recently sold. This method reflects the current market conditions and buyer preferences. In the cost approach, which factor is least likely to affect the valuation of a new building? Is it A, land value, B, construction costs, C, depreciation, or D, building materials? The answer is C, depreciation. Why this question may seem a bit tricky, the cost approach focuses on the cost to build new, so factors like land value and construction costs are crucial. Depreciation is less relevant for new buildings. A real estate investor is considering purchasing an apartment complex and wants to determine its value based on the income it generates. Which valuation approach should they use? Is it A, market approach, B, income approach, C, cost approach, or D, sales comparison approach? The answer is B, income approach. The income approach is best for properties that generate income, like rental properties, as it evaluates the present value of expected future income. Which approach to value is most appropriate for a unique, custom-built home with no comparable sales? Is it A, market approach, B, income approach, C, cost approach, or D, sales comparison approach? The answer is C, cost approach. The cost approach is suitable for unique properties where comparable sales are unavailable, as it estimates value based on the cost to replace or reproduce the property. A homeowner is trying to refinance their mortgage and needs an appraisal. The appraiser finds that the home is in a rapidly appreciating neighborhood with many recent sales. Which approach is likely to provide the most accurate valuation? Is it A, market approach, B, cost approach, C, income approach, or D, depreciation approach? The answer is A, market approach. The market approach is most accurate in rapidly changing markets with many recent sales, as it reflects current market conditions. CMA and broker price opinions. What is the primary purpose of a comparative market analysis in real estate? Is it A, to determine the exact market value of a property, B, to estimate the value of a property based on recent sales of similar properties, C, to calculate the future appreciation of a property, or D, to establish the tax value of a property? The answer is B, To estimate the value of a property based on recent sales of similar properties. A CMA is used to estimate the value of a property by comparing it to similar properties that have recently sold in the same area. Why might a broker price opinion be considered less reliable than a formal appraisal? Is it A, BPOs are conducted by licensed appraisers? B, BPOs include more detailed property inspections? C, BPOs are less comprehensive and not conducted by licensed appraisers? Or D, BPOs are used exclusively for mortgage lending? The answer is C. BPOs are less comprehensive and not conducted by licensed appraisers. Why this question may seem a bit tricky. BPOs are less comprehensive and not conducted by licensed appraisers, which can affect their reliability compared to formal appraisals. A real estate agent is preparing a CMA for a client selling their home. The agent notices that a similar property sold for a significantly higher price due to recent renovations. How should the agent adjust the CMA? Is it A, ignore the renovated property as an outlier? B, use the higher price without adjustments? C, average the prices of all similar properties? Or D, adjust for the renovations to reflect a more accurate comparison? The answer is D, adjust for the renovations to reflect a more accurate comparison. The agent should adjust the CMA by considering the impact of the renovations on the property's value, ensuring a fair comparison. In what situation might a broker price opinion be preferred over a formal appraisal? Is it A, when a quick, cost-effective estimate is needed for a short sale? B, when determining the tax value of a property? C, when a detailed property inspection is required? Or D, when a lender requires a certified appraisal? The answer is A, when a quick, cost-effective estimate is needed for a short sale. Why this question may seem a bit tricky. BPOs are often used when a quick, cost-effective estimate is needed, such as in short sales or foreclosures. A homeowner is considering selling their property and asks their agent to perform a CMA. The agent finds that similar homes in the area have sold for varying prices. What should the agent focus on to provide the most accurate CMA? Is it A, the highest sale price in the area? B, the most recent sales of similar properties? C, the average price of all homes in the neighborhood? Or D, the lowest sale price in the area? The answer is B, the most recent sales of similar properties. The agent should focus on the most recent sales of similar properties to provide an accurate CMA. USPAP foundations and Florida appraisal requirements. What is the primary purpose of the Uniform Standards of Professional Appraisal Practice? Is it A, to establish ethical and performance standards for appraisers? B, to set property tax rates for local governments? C, to regulate real estate transactions? Or D, to provide marketing guidelines for real estate agents? The answer is A, to establish ethical and performance standards for appraisers. USPAP provides ethical and performance standards for the appraisal profession, ensuring consistency and reliability in appraisal practices. In Florida, which entity is responsible for enforcing USPAP compliance among appraisers? Is it A, the Appraisal Foundation? B, local real estate boards? C, the Florida Real Estate Appraisal Board? Or D, the National Association of Realtors? The answer is C, the Florida Real Estate Appraisal Board. Why this question may seem a bit tricky. The Florida Real Estate Appraisal Board enforces USPAP compliance, not the National Appraisal Foundation or local real estate boards. An appraiser in Florida is asked to appraise a property for a mortgage lender, but is also offered a bonus if the appraisal meets a certain value. What should the appraiser do according to USPAP? Is it A, accept the bonus if the appraisal is accurate? B, refuse the bonus to maintain objectivity? C, negotiate a higher fee for the appraisal? Or D, complete the appraisal without disclosing the bonus offer? The answer is B, refuse the bonus to maintain objectivity. The appraiser must refuse the bonus to maintain objectivity and comply with USPAP's ethical standards, which prohibit accepting incentives that could bias the appraisal. What is a key requirement for appraisers under Florida's appraisal regulations? Is it A, submit monthly reports to the state board? B, conduct appraisals only for residential properties? C, join a professional appraisal organization? Or D, complete continuing education to maintain licensure? The answer is D, complete continuing education to maintain licensure. Appraisers in Florida must complete continuing education to maintain their licenses, ensuring they stay updated with current standards and practices. Real estate practice and disclosures. What is required by Florida law when selling a home built before 1978? Is it A, a radon gas disclosure? B, a lead-based paint disclosure? C, an HOA disclosure? Or D, a property defect disclosure? The answer is B, a lead-based paint disclosure. Sellers must provide a lead-based paint disclosure for homes built before 1978, as lead paint was commonly used before it was banned. Which disclosure is not required by Florida law when selling a property? Is it A, radon gas disclosure? B, lead-based paint disclosure? C, HOA disclosure? Or D, disclosure of neighbor disputes? The answer is D, disclosure of neighbor disputes. Why this question may seem a bit tricky, all options seem plausible, but only disclosures specifically mandated by law are required. John is selling his home and knows it has a radon issue. What must he do according to Florida law? Is it A, disclose the radon issue to potential buyers? B, fix the radon issue before listing the home? C, ignore the radon issue if the buyer doesn't ask? Or D, only disclose if the buyer requests a radon test? The answer is A, disclose the radon issue to potential buyers. Sellers must disclose known radon issues to potential buyers to ensure they are aware of potential health risks. What must be included in a Florida HOA disclosure? Is it A, the HOA's financial statements? B, a list of all HOA members? C, information on assessments and restrictions? Or D, the HOA's meeting minutes? The answer is C, information on assessments and restrictions. The HOA disclosure must include information about assessments, restrictions, and the existence of the HOA. Sarah is buying a condo in Florida and learns about a pending special assessment. What should she expect from the seller? Is it A, the seller to pay the assessment before closing? B, disclosure of the pending special assessment? C, a reduction in the purchase price? Or D, no obligation to disclose the assessment? The answer is B, disclosure of the pending special assessment. The seller must disclose any pending special assessments as part of the HOA disclosure requirements. Fair housing, ethics, and consumer protection laws. What is the primary purpose of the Fair Housing Act? Is it A, to prevent discrimination in housing based on protected classes? B, to regulate the pricing of real estate properties? C, to ensure all real estate agents are licensed? Or D, to provide housing subsidies to low-income families? The answer is A, to prevent discrimination in housing based on protected classes. The Fair Housing Act aims to eliminate discrimination in housing based on race, color, national origin, religion, sex, familial status, or disability. Which of the following is not a protected class under the Fair Housing Act? Is it A, race, B, disability, C, age, or D, familial status? The answer is C, age. Why this question may seem a bit tricky. The Fair Housing Act covers many classes, but age is not one of them, despite common assumptions. A real estate agent refuses to show a property to a family with children, citing safety concerns due to a nearby construction site. What law might this action violate? Is it A, Americans with Disabilities Act, B, Fair Housing Act, C, Equal Credit Opportunity Act, or D, Real Estate Settlement Procedures Act? The answer is B, Fair Housing Act. The Fair Housing Act prohibits discrimination based on familial status, which includes families with children. Which agency is responsible for enforcing the Fair Housing Act? Is it A, Federal Trade Commission, B, Consumer Financial Protection Bureau, C, Department of Justice, or D, Department of Housing and Urban Development? The answer is D, Department of Housing and Urban Development. The Department of Housing and Urban Development is tasked with enforcing the Fair Housing Act. A landlord advertises an apartment as perfect for singles and refuses to rent to families. What is the potential legal issue here? Is it A, violation of the Americans with Disabilities Act, B, breach of contract, C, violation of the Fair Housing Act, or D, infringement of tenant privacy rights? The answer is C, violation of the Fair Housing Act. This scenario could violate the Fair Housing Act, which prohibits discrimination based on familial status. Handling escrow funds, accounting, and FREC compliance. What is the maximum number of business days a broker has to deposit escrow funds into their escrow account according to FREC rules? Is it A, 1 business day, B, 3 business days, C, 5 business days, or D, 7 business days? The answer is B, 3 business days. Brokers must deposit escrow funds into their escrow account within 3 business days of receiving them, as per FREC regulations. If a dispute arises over escrow funds, what is the first action a broker should take according to FREC? Is it A, disperse the funds to the party they believe is correct, B, immediately return the funds to the buyer, C, notify FREC within 15 business days, or D, hold the funds indefinitely until the parties resolve the dispute? The answer is C, notify FREC within 15 business days. Why this question may seem a bit tricky. It tests knowledge of the correct procedural order. The broker must notify FREC within 15 business days of the dispute. A broker receives a check for escrow funds on a Friday. What is the latest day they can deposit the funds into their escrow account? Is it A, Wednesday, B, Thursday, C, Monday, or D, Tuesday? The answer is A, Wednesday. The broker must deposit the funds by the end of the 3rd business day, which would be Wednesday. What is the primary purpose of maintaining an escrow account in real estate transactions? Is it A, to earn interest for the broker, B, to provide a loan to the buyer, C, to pay for closing costs, or D, to hold funds securely until transaction conditions are met? The answer is D, to hold funds securely until transaction conditions are met. The primary purpose of an escrow account is to hold funds securely until the transaction conditions are met. During a real estate transaction, a buyer requests the return of their escrow deposit before the contract is finalized. What should the broker do? Is it A, immediately return the funds to the buyer, B, Review the escrow agreement and consult legal counsel if needed. C. Transfer the funds to the seller. Or D. Ignore the request until the contract is finalized. The answer is B. Review the escrow agreement and consult legal counsel if needed. The broker should follow the terms of the escrow agreement and consult legal counsel if necessary. Advertising rules, offers, and professional conduct. What must a real estate advertisement include to comply with Florida regulations? Is it A. the name of the brokerage firm, B. the agent's personal phone number, C. a disclaimer about market fluctuations, or D. the listing price of the property? The answer is A. the name of the brokerage firm. Real estate advertisements in Florida must include the name of the brokerage firm to ensure transparency and accountability. In Florida, which of the following is not required in a real estate advertisement? Is it A. the brokerage's name, B. the agent's license number, C. the property address, or D. the agent's contact information? The answer is B. the agent's license number. Why this question may seem a bit tricky, it tests knowledge of what is not required, which can be confusing when considering typical advertising practices. A seller receives multiple offers on their property. What is the ethical obligation of the listing agent? Is it A. accept the highest offer on behalf of the seller, B. negotiate only with the first offer received, C. present all offers to the seller, or D. reject offers below the asking price? The answer is C. present all offers to the seller. The listing agent must present all offers to the seller to ensure the seller can make an informed decision. During an open house, an agent tells a potential buyer that the property will definitely increase in value. What is the issue with this statement? Is it A. it is a breach of confidentiality, B. it violates fair housing laws, C. it is a form of puffery, or D. it is misleading and unethical? The answer is D. It is misleading and unethical. Why this question may seem a bit tricky. It involves understanding the implications of making guarantees about future market conditions. An agent is preparing an advertisement for a new listing. The seller insists on including a statement that the property is the best deal in town. What should the agent do? Is it A. include the statement as requested, B. advise the seller against unverifiable claims, C. consult with the brokerage for approval, or D. add a disclaimer to the advertisement? The answer is B. advise the seller against unverifiable claims. The agent should advise against making unverifiable claims to avoid misleading potential buyers. Investment, property management, and specialty areas. What is the formula for calculating the return on investment in real estate? Is it A. net profit divided by gross revenue, B. net profit divided by total investment cost, C. gross revenue divided by net profit, or D. total investment cost divided by net profit? The answer is B. net profit divided by total investment cost. ROI is calculated by dividing the net profit by the total investment cost, then multiplying by 100 to get a percentage. Sarah bought a rental property for $200,000 and spent $50,000 on renovations. If she sells it for $300,000, what is her return on investment? Is it A. 20%, B. 25%, C. 30%, or D. 15%? The answer is A. 20%. ROI is calculated by subtracting the total cost from the sale price, then dividing by the total cost. Here, the net profit is $50,000 on a $250,000 investment. Which of the following is considered a passive investment strategy in real estate? Is it A, flipping houses, B, managing rental properties, C, developing land, or D, investing in REITs? The answer is D, investing in REITs. REITs are a passive investment strategy, allowing investors to earn income without actively managing properties. John invested $150,000 in a commercial property and expects an annual return of 8%. If the property appreciates by 5% in the first year, what is John's total return on investment for that year? Is it A, $12,000, B, $7,500, C, $19,500, or D, $15,000? The answer is C, $19,500. John's total return includes both the expected annual return and the appreciation. The expected return is $12,000, 8% of $150,000, and the appreciation is $7,500, 5% of $150,000, totaling $19,500. Property management responsibilities. What is the primary responsibility of a property manager? Is it A, maximizing the return on investment for the property owner, B, ensuring tenants pay rent on time, C, handling all legal disputes, or D, renovating properties? The answer is A, maximizing the return on investment for the property owner. A property manager's main duty is to maximize the return on investment for the property owner by maintaining the property and ensuring it is leased to reliable tenants. Which of the following is not typically a responsibility of a property manager? Is it A, collecting rent, B, coordinating maintenance, C, selling the property, or D, screening tenants? The answer is C, selling the property. Why this question may seem a bit tricky, property managers often handle many tasks, but they do not typically engage in selling properties, which is the role of a real estate agent. A property manager notices a significant increase in tenant complaints about maintenance delays. What should the manager prioritize to address this issue? Is it A, increasing rent to cover additional maintenance costs, B, improving the maintenance request process, C, hiring more security personnel, or D, offering discounts to tenants? The answer is B, improving the maintenance request process. The property manager should prioritize improving the maintenance request process to ensure timely responses, which will help reduce tenant complaints. A property manager is tasked with reducing the vacancy rate in a residential complex. What strategy should they implement first? Is it A, increasing rent to attract higher-income tenants, B, reducing maintenance staff to cut costs, C, implementing stricter tenant screening processes, or D, enhancing marketing efforts? The answer is D, enhancing marketing efforts. Enhancing marketing efforts can attract more potential tenants, directly addressing the issue of high vacancy rates. Florida Landlord-Tenant Law Basics. Under Florida Landlord-Tenant Law, what is the maximum amount of time a landlord has to return a tenant's security deposit after the lease ends, assuming no deductions are made? Is it A, 7 days, B, 15 days, C, 30 days, or D, 45 days? The answer is B, 15 days. Florida law requires landlords to return a tenant's security deposit within 15 days, if no deductions are made. This ensures tenants receive their deposits promptly. Lisa, a landlord in Florida, wants to evict her tenant John for non-payment of rent. She decides to change the locks to force him out. What is the legal issue with Lisa's action? Is it A, Lisa should have given a 3-day notice before changing the locks? B, Lisa should have waited until the lease expired? C, Lisa cannot legally change the locks to evict John? Or D, Lisa should have increased the rent instead? The answer is C, Lisa cannot legally change the locks to evict John. In Florida, landlords cannot use self-help methods like changing locks to evict tenants. They must follow legal eviction procedures through the court.
Thanks for watching. If you found this exam review helpful, be sure to subscribe for more real-world practice and topic-focused study videos. And visit Birdsy.ai to start your free trial of Birdsy, your AI-powered study partner.